Good evening. Good evening, all my students. Good evening, okay? Hello. The class is going to start very soon. Good evening, everybody. Please come to this online classroom, okay? Now, let me proceed to my desk in order to deliver my lecture, okay? Hello. Hello, all my students. Good evening, okay? So before I start my lecture, let me just extend to you my best wishes for happiness and peace. Simply because today it is the Makha Bucha days in Thailand, okay? So this is in fact a public holiday, but I feel that I need to also have a lecture this evening as well. And this lecture is now recorded in order to be made available for your viewing at your own convenience on YouTube. Okay, so even though this is a public holiday, you will not be affected by this public holiday. Okay, we will have our class as usual. Okay, so again, right, the lecture today, it is going to be on the topic which is very special. Okay, so on this special day, the Makha Bucha Day, the lecture is going to be on the topic which is also special. Okay, so we are going to explore legal issues okay, in the e-commerce or e-transactions law in Thailand. Okay, so nowadays we are indeed in the era of e-commerce. Okay, we are in the era of the use of electronic means in communications, so that this puts forth some new problems in the law as well. Okay, so if you can see, I mean, around us we are in fact been surrounded by electronic means. Okay, that we have this evening online teaching, which is also the teaching in an electronic mode. Okay, you may also do your online shopping today. Okay, so very few people now, make use of paper, handwritten paper, or the manually prepared paper. So we switch from paper to something electronic. We switch from paper into electronic messages. Okay, so this seems to put forth some legal problems in every country, okay, including in this country, so that we in this country have now the law known as the Electronic Transactions Act, okay, or ETA. Okay, this act has been in fact enacted in this country, okay, since 2001. Okay, so up to now it is now is 2021, almost in fact 20 years. Okay, since its the enactment. Okay, so the passage of 20 years seem to be quite long, but I should also say that even though we witnessed passage of about 20 years since this act, okay, that has been enacted, not many people seem to have proper understanding of this law. Okay, so I think that time is right for us to indeed explore, okay, there are some key principles of this legislation. Okay, so before I go to the fundamental principles or fundamental provisions of this law, let me just give you a little bit of background, okay, of of this act. Right, as I have mentioned, now we switch from the paper into something electronic. Okay, that we use indeed less and less paper and more electronic records. Okay, so the paper-based environment is more and more replaced by the paperless environment, where people use more and more electronic records. Okay, now we have to come across one word. Okay, the electronic records, or we also use the word data message. Okay, data messages or electronic records, these two words are interchangeably used. Okay, so what it means by electronic record or a data message is this. Okay, it is the message. It is the of course, I mean, as the name suggests, it is a message in the form of data. Okay, put simply, they are messages created by computers. They are messages generated, by electronic means. Okay, so what we have seen is again that normal documents or the manually prepared documents are more and more replaced by electronic records or data messages. Think of situations in which we do the online shopping. Remember in the old day, I should say that in the before the advent of the internet, okay, that we seem to go to a shopping complex, we go to department stores in order to do our shopping, okay, and we pop in this shop and that shop, okay, we hang around. But nowadays we do not need to go to shopping centers, okay, or shopping malls anymore, because we can just have the online shopping, okay. You can just make use of your computer, you can just make use of your tablet in order to do the online shopping, okay. There are so many websites, there are so many social media by which you can do your online shopping, okay. So this is what we have now today. So when we do the online shopping, okay, so we do not make use of paper anymore, okay. We make use of what? We make use of electronic records or data messages, simply because we send electronic messages, okay, in order to place our orders, okay. For example, so that what we see is this, okay, the manually prepared documents are more and more replaced by data messages, okay. Handwritten signatures, when we use the normal documents, sometimes we need to sign, let's say that we need to sign a contract, okay. When we no longer use paper, or we very much less, okay, we use the paper much less than before, okay. So we use more and more electronic records or data messages. So that means that we cannot just sign the e-document, okay. The e-documents are in place of manually prepared documents. That when we have with us e-documents, right, sending messages to place our orders, something like that, okay. So when we place our orders, when we transmit messages, let's say that we check our tablet in order to place our orders, okay, with some the online shops, okay. So we do not have paper. So when we do not have normal paper, we cannot just sign like this. We cannot just sign, using our handwritten signature, but we can also sign using, a new form of signature known as the e-signature. Okay, so this is also the thing which we turn into, right? So when manually prepared documents seem to be the less common, okay, and there are more and more replaced by data messages, right? So when we have sort of litigation, okay, so the thing is that this evidence seems to be in the form of digital evidence as well, okay, rather than in the form of normal evidence, let's say paper evidence, okay. So that's why in this era, okay, that we are surrounded by the electronic things, right? Even when we make offer, or when we make acceptances in order to make contracts, we do not use normal paper, but we use what? We use data messages in order to send our offers, or in order to make our acceptances, right? So this seems to be commonplace now today. Okay, this this phenomenon seems to be very, very commonplace nowadays. Okay, so when we talk about electronic methods, well, there are so many methods. Okay, ranging from what? Ranging from telephone, right? Telephone. If you look at the telephone in the old day, okay, so it seemed to be very, very. It seems to be not very, very advanced. You may just dial like this, right? But now you can just touch the button, or you can just swipe. Now we use just smartphone, so that you can just swipe rather than dialing like this, right? We can also, we also have what telex machines. Okay, I mean the telex machines seem to be now more and more obsolete, and we also have the fax machines. Okay, we may just transmit our messages via facsimile. Okay, and we may also use the EDI or electronic data interchange, where two computers can be connected. Okay, and they are in a position to have communications as if that there were some human beings over there. Okay, but in fact they are not human beings over there. Human beings seem just mean to program the computers in order to be able to talk to each other. Okay, so the computer at one side will be able to talk with the computer at the other side. Okay, so that messages can be transmitted. Okay, without direct human intervention. Okay, that is the world of EDI or electronic data interchange. Okay, and now we are in the era of the internet. Okay, so I do not need to say many words about this, because everything about this. Okay, we have the World Wide Web, we have also the email, we make use also many social medias like Facebook, Instagram, Line, WhatsApp, okay, the WeChat, YouTube, and the most recent one now, Clubhouse. Okay, so that these are all the social media which are in place nowadays, and that will make our lives very, very convenient. Okay, so everything which you see on screen here, okay, they are all electronic modes of communication. Okay, or electronic methods. Okay, so when people switch from paper into data messages, okay, they make use of electronic means. Okay, so and nowadays, right, if we talk about the internet, okay, that it seems to be the commonplace now. Okay, with respect to World Wide Web. Okay, if we look at the web evolution, okay, we can see that the web seem to have great evolution, ranging from Web 1.0 and then from 1.0, okay, towards Web 2.0 and now to Web 3.0. Okay, Web 1.0, it is the web which in fact they did not quite the promote sort of collaboration between users. Normally Web 1.0 was intended to do what? To just make available information. So you just make available your information for other people to read, and users of the internet did not seem to have collaboration. They did not seem to have sort of the interaction. Okay, so the users normally just read the content or information which was made available on the web. Okay, you did not have feedbacks, you did not have comments from users, but from Web 1.0 toward Web 2.0, okay, it is the web whereby people have sort of interaction or collaboration. Okay, when you do not just make available your content on the web, okay, but people who read your content will also have some sort of collaboration, okay, or the feedbacks or interaction. Okay, look at some application like Facebook, okay, Instagram, or the like. Right, when you just put something on Facebook, it doesn't mean that you just make your content available for the viewing. But when you want data users also to have some feedbacks. Maybe you expect some comments from the users. Okay, so that people have what? People have also collaboration. Okay, feedbacks. Okay, something like that. Okay, so that is the emergence of Web 2.0. What is Web 3.0? Web 3.0, it is something similar to Web 2.0. It is a Web 2.0 plus some advancement. Okay, advancement in the sense that the collaboration or cooperation seem to be the much greater. Okay, so the Web 2.0 seem to be based upon what? Seem to be based upon the technologies, including semantic technologies. Okay, it is a Web 2.0 plus some greater features. This greater features include the semantic technology, which which allow the search or analysis to become more efficient. Because it's make use of what? It is make use of the computer ability, greater ability to understand the meaning. Let's say that when you want to search something, your computer will just direct you to just direct information, right? Because it's make use of ability to understand the meaning of words, so that you will be presented with more accurate, your accurate responses. You will be presented with many, accurate information. When you do the searching, all right, and when you just make analysis of data with the assistance of what is known as the semantic technology. And Web 3.0 also resorts to AI or artificial intelligence. For instance, when you are driving, to one city, right? Sometimes your mobile phones will present you with some information, about what, about, let's say, about where to eat. About something which is happening in this area. That means that your computer, your smartphone, which look like a computer, or your tablet, which functions as a computer, seem to know what's going on around you, because the web, the web seems to be working on the basis of artificial intelligence, so that we are now in the era of Web 3.0. It is again the Web 2.0 plus some greater features, which makes, of course, our life very, very convenient. So in this country, in Thailand, the government, in fact, the government, the military-led government now, seem to just promote what is known as the Thailand 4.0, the notion, Thailand 4.0 concept, whereby it has been propagated that, well, everything seems to be run by what? Run by the innovation. So our industry, our lives will be founded upon creativity and innovation. So that everything seems to be smart. We will have smart industry. We will have smart city, and we will also have smart people. Everything seems to be guided and drawn by creativity and innovation. This is the concept propagated by the government. The military-led government. Well, it's a good idea. But the government will have to make that real. In order for Thailand to drive at the Thailand 4.0 as convinced by the government. The leader government, of course, Prime Minister needs to also be IT literate first. I'm not quite sure whether our Prime Minister right now is fluent or is IT literate. So I'm not quite sure about this. So that is not my job to make comments in this class. So we are going to just have some discussions on this in the other in other fora, not in this forum. So we also have some new word now today. Like Bucha. So we people say that now we are in the vulgar world, the so-called vulgar world. What is that? Vulgar, it is the word which is consists of V for volatility, volatility, and G for uncertainty, C for complexity, and A for ambiguity. This means that everything around us seems to be what? Everything around us seems to be based upon volatility, uncertainty, complexity, and ambiguity, which makes, in fact, our life very, very challenging. So we will have to adapt ourselves as well in order to be ready for this new world. So now, what we are saying is that now we are in the era where more and more people make use of what? more and more people make use of data messages or electronic records in place of paper, okay, in order to make transactions. Okay, so when more and more people switch from paper or the manually prepared documentation into the data messages or electronic records, okay, so that will necessitate the enactment of special legislation, okay, which is now known as the Electronic Transactions Act, or ETA for short. Right. Let me just tell you, that this ETA, or again, the Electronic Transactions Act, of course, has been enacted in 2001. Okay, up to now, it has the life. It has it is now almost 20 years old, right? It has come into force since December, since something like March 2002, okay? Because this act was published in the Government Gazette in December 2001, and this act has been specified to come into force 120 days upon its publication in the Government Gazette. This means that it came into force something like in March 2002, okay, up to now. This act seems to be almost 20 years old, okay, and this act has been indeed enacted on a few occasions by the ETA number 2, the ETA number 3, and the ETA number 4. The ETA number 2, okay, the amending act came to the world in 2008, okay, following the coup d'etat staged by General Son Thi in the something like 2007, something like that, okay? And the other two amending act, the ETA number 3 and the ETA number 4, okay, came out in the 2019, okay, the following the coup d'etat staged by General Prayut Chan-o-cha. Okay, so we can see that the amendments on two occasions came over, okay, at the time of the coup d'etat. Okay, so at the time of coup d'etat, we did not have a proper parliament. We had the so-called the National Legislative Assembly, okay, which functioned as the parliament, okay, which functioned as parliament, or which functioned as our national the National Assembly, so that the members of the National Legislative Assembly, as appointed by the coup d'etat, did not seem to be from well-qualified people, okay, even though they claim that they chose well-qualified people to be to sit in the National Legislative Assembly, which function as parliament, but in reality, okay, the many people seem to be connected with the army or with the military troops, okay, so that we in fact did not have well-qualified members, so that when the draft law came to the National Legislative Assembly, the draft laws didn't seem to undergo sort of the meticulous consideration, right? That's why sometimes the draft law seem to contain the flaws, and the amending act seem to make the act worse in rather than making it better. Okay, so we will defer our discussion on this to the late part of this lecture. Okay, let me now tell you that in fact our ETA it is the product of what? It is the product of borrowing the concept from the United Nations. Okay, so before going to that point, let me just tell you that the ETA scope of application is this. Okay, if you look at the title of this act, okay, it is the Electronic Transactions Act, not the E-Commerce Act. Right. So when our act title is the E-Transactions Act and not E-Commerce Act, that means that its application is much broader than e-commerce. It applies to the e-transactions in civil and commercial matters, whether or not the transaction concerned it is commercial in nature. So it applies to commercial transactions and non-commercial transactions alike. Okay, it applies to even transactions, okay, made by state agencies or made with state agencies, okay. Let's say that, if I, as a consumer, make a contract with a shop online, okay, an online shop. If I, as a consumer, make a contract with a company, okay, which runs a business online, that is the B2C, business to business, okay. So it also falls within the application, within the scope of application of this act. Or let's say that I live in my house and would like to just sell my car. I send an email to my neighbor next door in order to let him know that I make an offer to sell my car. In this case, I want to sell my car not just for the commercial purpose. I just want to just make the enough money for my living. Okay, I want to sell my car because now it is the it is the living among the COVID-19 situations. I do not have much money, so I need to sell my car for my living. Okay, so I just send the messages to my friends next door using the email. Okay, so in this case, the transaction, it is not for a commercial purpose, but this transaction is based upon an electronic method. Okay, so it is also the transaction which also falls within the scope of application of this act as well. Okay, so this is the B2B situation, right? Or when company A and company B, when they want to make contracts, okay, let's say that they make use of what? They make use of emails. They make use of the line. Okay, they just send the messages via line application. Okay, in this case, okay, when two companies have interactions in this fashion, okay, so the transactions are electronic transactions between two commercial entities, so that the transactions in question, it is also they are the C to C transactions. Okay, sorry, not C to C, the B to B, right? B2B transactions, business to business, because it is the transaction made between company A and company B, right? And as I have mentioned, the our Act, the ETA also apply to B to G or even G to G transactions. Okay. Let's suppose that I would like to just establish my company. Okay, when I want to establish my company, I need to go to the Department of Business Development or DBD in this country. I need to just apply. I need to just submit my application for for what? For establishment of my company. Okay. So in this case, when I sent my application online, right, it is the application online. Okay, so it is a transaction in an electronic form. It is also the e-transaction, which is made between what? Between me as an individual and the government. Okay, so this transaction, it is the B2G. Okay, business and government. Let's say that I would like to run a company. Okay, of course now I'm ready to go. I'm ready to run a business. Okay, so even though I am a private individual, but it's maybe considered as business. Okay, because I want to run a business, so that when I send my application to the Department of Business Development, which is within the Ministry of Commerce, this transaction which is made which is made by the an online means. Okay, this is the B2G transaction, business to business. Or when when two state agencies communicate with each other, okay, using some online, using some electronic methods. Okay, those transactions are the J to J transactions, of government to government transactions, and it might also fall within the scope of the application of the ETA as well. Okay, so before going to explore some important or some fundamental principles in this ETA, let me just give you some the historical backgrounds of this legislation. Okay, in fact, this legislation, the ETA, the Thai ETA, okay, it is a product of what? A product or a result of the IT 2000 policy. At that time, when we had a turn of, when we were going to turn from 1999 to 2000 at that time, okay, we in this country in Thailand, we launched the so-called the IT 2000 policy, okay, that in fact was the something in the implementation of the Eosin framework agreement. In ASEAN, okay, we have had an agreement known as the Eosin framework agreement, okay, which was intended to put forth electronics world in ASEAN. Okay, every nation of ASEAN would have to be turned into electronic nations. Okay, so that Thailand as part of ASEAN, okay, as part of ASEAN, we would have to turn Thailand into e-Thailand. Okay, so it was felt at the time that in order to be turned into e-Thailand, we would have to have sort of legal infrastructure by enacting the many pieces of legislation. Okay, so that's why at that time we set up the committees in charge of drafting law on e-transactions. We also had the draft law on e-signatures, electronic signatures. We also had the draft law on EFT or electronic funds transfer. Okay, in order to cater for the transfer of money from the one person to another, and we also wanted to have the law on computer crime. Okay, we wanted also to put forth the law on data protection. Okay, and finally, we also had the draft law on universal access in order for everyone in this country, wherever he or she was, to be able to have access to the IT infrastructure. Okay, so at the moment, okay, today, this evening, we do not don't talk about every piece of legislation. Okay, almost all these drop laws have now become law. Okay, so we do not talk about every piece of legislation here. Okay, but we are going to just talk about the first two. The first two drops, the drop law on electronic transactions and the drop law on electronic signatures. They were merged. They were merged into the same draft, and it has become the act known as the ETA, or the Electronic Transactions Act. Okay, the 2001 in this country. Okay, which is our concern this evening. Okay, so let me just tell you the reasons for having this ETA. There are two reasons for having this ETA. Okay, two main reasons for putting forth enactments of this special legislation. Okay, the first one is to remove legal obstacles embodied in the existing law. We are going to go through this very, very shortly. Okay, the second reason is this. The second reason is that we would have to lay down some new rules, okay, in order to apply the existing rules. This means that we have some existing rules of law, but in the new world, in the world of data messages, in the world where people make use of computers and data messages, those existing rules, okay, will not be able to be applied without some more explanations. Okay, without some supplementary rules. If I give you an example, let's suppose that, in fact, this seems to be witnessed in the many countries. Many countries' laws seem to make the distinction of communication into two main modes. Is a tennis mode of communication and a non-instantaneous mode of communication. Okay, with respect to an instantaneous mode of communication, a communication will become effective when it becomes known to the other party. This is what is specified in Thai law. And in this country law, if you just make a communication, okay, not in an instantaneous mode, but in a non-instantaneous mode, let's suppose that you send your offer using the letters, okay? You just send your letter in order to make your offer. You are A, the other one is B. You send a letter, okay, in order to make an offer to sell your car. Okay, this is a communication which is made in a non-instantaneous mode. The law in this country says that your offer, your declaration of an intention in this mode, in a non-instantaneous mode, will become effective when it is received by the other party. It will become effective when it reaches the other party. Reaches mean what? When it reaches the other party, that's mean that when it is received by the other party. So that the rule of law as indeed embodied in our civil and commercial code says that, okay, if a person makes the declaration of an intention, okay, to another one who is not in the first one's presence, then that declaration of intention will be effective when it is received. So that the rule, it is the receipt rule. If we deal with, if we make use of what? Or manually prepared documentation, let's say that we use paper, okay? So let's say that when we send our paper-based offer by post, once the postman drops your letter, okay, in the post box of the addressee, then we can say that the addressee has received your letter, okay? That is something, something not difficult, but in the new world, where communications seem to be based on networks, when messages are transmitted and received via networks, how can we determine the term of receipt? How do we know that an email message sent by A has been received by B, when we do not know the time at which a message is received? That means that we cannot just apply the rule of law which has been laid down by law, okay? The law says that the communication made in a non-instantaneous mode will become effective when it is received by the other party. But in the new world, when communication is made via networks, we simply don't know, okay, when the message sent by the sender is received by the addressee, so that the ETA, so that we need the new law, okay, putting forth or specifying, the rule of law about the term of receipt. Okay, so there are two reasons for putting forth the special legislation, okay, in order to be responsive to the computer world. First, okay, our ETA, the ETA has been enacted in order to remove legal obstacles, which we will explain shortly, okay. And secondly, the ETA needs to be enacted in order to lay down some new rules for applicability to computer-based communications, okay. Now we are going to come to the first reason. The main reason for enactment of this special act or this special legislation is to remove the legal obstacles in existing law. What is that? When we talk about legal obstacles, okay, it is a situation in which the law contains some provisions which set out some requirements. The requirements which can be complied with, or which can be satisfied by the use of a traditional means of communications, i.e. by the use of paper. Okay, we will be fine if we use papers in order to make transactions. The law sets forth some requirements, and these requirements can be complied with. These requirements can be observed if we use paper-based documentation, but these requirements may not be able to be complied with. Okay, when people switch from the paper documentation into electronic methods, when people use data messages in place of paper, then people will not be able to comply with the requirements set forth by law. At the time when those requirements, they were set, nobody who was in charge of what? Who was in charge of drafting law did not know anything about data messages because data messages did not exist in those days. So when law drafters, set requirements, they just thought of what was going on around them. Right. They just set forth, for example, the requirement as to writing. The law requires, for example, some contracts to be made in writing. The law requires some transactions to be supported by written evidence or evidence in writing. In some scenarios, in some cases, the law also requires some transactions to be signed, so that we have, the requirement as to signature. The law also requires that if we have to present some documents, we are required to do what? We are required to present only original documents. Right. When the law drafters, that set forth these requirements in the old days, they never knew that in the future there would be data messages. There would be messages which would be, generated by computers. Right. So that when they set these requirements, all these requirements would be able to be complied with when people use paper-based documentation. For example, if you just want to make a contract, you want to make a contract of sale. The Thai law say what? Thai law say that in order to make a contract of sale of movable property, okay, at the price of at least 20,000 baht, then the contract would have to be supported by written evidence, and the contract would have to be signed by the party liable. Right. So these requirements did not seem to generate any problems, because when people made contracts using paper, then we would be able to comply with all these requirements. Requirements as regards written evidence and requirements as regards signature. When you use a paper, right, you will be able to just sign your names, and the paper would be written evidence for the purpose of the law. But imagine the situation where you just do your online shopping. When you do your online shopping, you do not use any paper. You just send your messages. You go to, you just visit a website, and the website has sort of the digit form for you to just fill in your order. You place your order. Okay, you just type using the keyboard on your computer or using your tablet. You just type some messages, right? You send your messages, which are of course data messages, right? In order to just place your order. When the contract is formed, and let's suppose that the seller does not want to just deliver the goods to you. If you want to just bring a legal action against the seller, you need to have a signature of the seller. You need to have your contracts supported by written evidence. How can you have written evidence? How can you have a signature when you did not use paper, but you just transmitted your electronic messages? See, that means that this provisions of law, these requirements set forth by law seem to be an obstacle because, okay, they seem to be the legal obstacles because they could not be complied with when people involved, okay, make use of data messages in place of paper-based documentations in order to make transactions, okay. So put simply, the legal obstacles they are in the form of people not being able to comply with the requirements set by law when people do not use paper but they use data messages in place of paper. Right. So in fact, that there are some more examples of requirements in Thai law. Let's say that the in a loan of money. Thai law, the civil and commercial code says that if you make a loan of money for a sum exceeding 2,000 baht, then you need to have your contract, okay, that supported by written evidence, and you also need to have the signature of the borrower. If you do not have this, okay, that means that your contract, even though it is validly formed, it will not be enforceable by action. If one party is in breach of contract, then the other party may not initiate litigation before the court of law, right? And also in a contract of hire purchase, okay, the civil and commercial code of Thailand says that, okay, it has to be made in writing, otherwise it will be void. A contract of insurance is required by the civil and commercial code to be supported by written evidence as well and signed by the party liable as well. See, so all these are requirements set by the law, okay, in the days on which nobody knew anything about the internet, nobody knew anything about data messages, so that everyone seemed to be able to observe these requirements if paper documentation is used. But when we switch from paper documentation into data messages, then we will not be able to comply with these requirements. Okay, when you do shopping online, how can you put your signature? When we talk about the signature, of course, the ordinary language will have to be used. The signature, according to the ordinary language, means the handwritten signature. So when the law say that your contract needs to be signed, we may not, interpret the law as meaning e-signature. Okay, so that the provision of law or the requirements set forth by the law did seem to be an obstacle because it could not be complied with when people did not use paper but they made use of data messages in place of paper. Okay, we indeed on this point have an example from this case, the case which has been brought before the Supreme Court. This case was decided in 1994. Right. This case was concerned with a contract of sale. In those days, okay, the law, the CCC, our civil and commercial codes required that a contract of sale of movable property, okay, would have to be supported by written evidence and would have to be signed by the party liable when the price agreed was only 500 baht upwards. Now the figure 500 has been changed into 20,000. But at the time when the Supreme Court decided this case, the law at the time required a contract of sale of movable property at the price of at least 500 baht to be supported by first written evidence and secondly to be signed by the party liable. So if the buyer wanted to sue the seller, then the buyer would have to have written evidence and the signature of the seller. And in this case, the contract of sale was made by the use of this device. This device is what? Is telex. Okay, the telex. Nowadays, telex seem to be almost obsolete, even though it is still in use. Okay, but it just seems to be more and more. I mean, it is becoming more and more obsolete now. Okay, so it's look like the old-fashioned typewriter. Okay, you would have this machine equipped with this keyboard. If you are the buyer, you wanted to just place your order. You wanted to buy steam rice. Okay, the product here in this case was steam rice. The buyer wanted to buy steam rice. The buyer just use this telex. The buyer just key messages in order to place the order to buy steam rice. These messages would be transmitted to the seller. At the seller's side, the seller also had this kind of machine. Messages which were transmitted by the buyer would be appearing at the seller's side. The seller's side, the telex machine at the seller's side would print messages sent by the buyer onto this paper which was equipped with the machine. Okay, so this is how communications by telex look like. Okay, the thing is that when communications between the sellers and the buyer were made via telex machines like this, later the seller was in breach of contract, so that the buyer wanted to sue the seller. When the buyer wanted to bring legal actions against the seller, the buyer was required by law to have what? First, again, to have written evidence, and secondly, the signature of whom? Of the party liable. In this case, when the buyer wanted to sue the seller, the buyer would have to have the signature of the seller. The court held that, this contract would not be enforceable by action simply because in this scenario, how could the parties have a signature? It would be impossible. Signatures just meant, the handwritten signature, but when by the buyer and the sellers made use of this device, the telex machine, they would not be able to just, sign their names. They would not be able to enter their signatures. The signatures, of course, the word signature would have to be interpreted as a handwritten signature, because if we do not have any specific law, if we do not have any specific law providing for the use of an e-signature, we would have to interpret the word signature as meaning just handwritten signature, because this is the word to be given the meaning, according to its ordinary meaning. Right. So in this case, it was held by the Supreme Court that the contract between the seller and the buyer would not be enforceable by action simply because these two requirements were not present. Okay. In particular, there was no signature on the part of the parties. Right. So what we learned from this case is that when people made use of what? When people made use of electronic means, they would run the risk of not being able to comply with the requirements set forth by law. In this case, when they made use of this telex machine, they would not be able to comply with the requirement of written evidence and the requirement of signature. Okay, perhaps when we talk about the requirements of written evidence, the party had, because the messages would have to be printed on a piece of paper like this, so that would constitute written evidence, but the sellers and the buyer would not have signatures, because via this machine they could not just enter their signatures, right? So the more people switched from paper into something modern, into something electronic, they would run the risk of not being able to comply with the requirements set forth by the law. So Is that the legal obstacles? Of course, yes. But it is the legal obstacles. Then how do we remove this kind of legal obstacles? How to remove it? Of course, I mean that we have the act. Okay, we now have the ETA in this country, as with some of the countries in this country. In Thailand, we have the Electronic Transactions Act 2001. Okay, the question is how this act removes. Okay, how this act removes legal obstacles which we have discussed. The answer is this. This act removes all legal obstacles by the use of the so-called functional equivalent rule. Functional equivalent rule, what does it mean? That means that two things are going to be treated as equal. Two things are going to be treated as equal in terms of functionality. The first thing is what? The first thing is the paper-based method. Any paper-based method, okay, this means that it is communication which is founded upon paper-based documentation. Okay. The second thing is an electronic method. So that these two methods, the paper-based methods and electronic methods, should be treated in the same way. They should be treated equal or equivalent. Okay, when people make transactions, if people make transactions using paper-based documentations, and it functions in the sense that it is valid, it is enforceable by action, then the people may also make the same transaction using electronic methods. Put simply, using data messages. If people make a transaction in the form of paper-based documentation, and that transaction is going to be valid and is going to be enforceable by law, then people may make the same transaction in the form of data messages, so that there would not be any difference between the use of a traditional means of communication, i.e. the use of paper, and the use of modern means of communications, i.e. the use of data messages. If you use paper and it functions, it is valid, it is enforceable by law, you can also, you can also make use of data messages in order to enter into any transaction. Okay. A transaction which is entered into by the use of a data message will function in the same way as a transaction which is made by the use of the use of paper-based documentation. Okay, so that there should be no difference. There should be no discrepancy between the use of paper and the use of data messages. When I say the use of paper, you should know that means the use of what? The use of traditional means of communication. Okay, normally, a traditional means of communication is what? It is based upon the use of paper. And when I say, when I say the use of data messages, that means the use of what? The use of modern means of communications. The modern means of communications are conducted by what? By data messages. Correct? So this functional equivalent rule, it is introduced by the ETA in order to get rid of legal obstacles. Right? Now this functional equivalent rule is embodied where in the ETA? It is embodied in Section 7 of the ETA. If you look at Section 7 of Thailand's ETA provides as follows. Information shall not be denied legal effect and enforceability solely on the grounds that it is in the form of a data message. See, what does it mean here? It means that if you make if you enter into any transaction using a data message, nobody can just deny that it is not going to be given legal effect. Nobody cannot deny its legal effect. Nobody can just say that, sorry, I mean your transaction is not going to be given legal effect because you do not use paper but you use a data message. If you want to deny, the legal effect, if you want to deny enforceability of any transaction, okay, you will have to just use some of the reasons, okay? You cannot just say that, well, it is not enforceable, it is not valid, it is not going to be given legal effect because it is in the form of a data message. So this reason alone is not enough. Okay, so in this way, this second seventh, it is the functional equivalent rule, okay, which say that from now on we can just make any transactions in the form of data messages. Okay, so this provision of law seems to be, in a way, seem to be a permitting avenue for us to just enter into transactions based upon data messages or based upon the use of data messages. You are now free to switch from paper or paper-based documentation into data messages or e-documents, see, in order to make transactions. Okay, so now this second 7, it is a green light given to us to embark on electronic methods of communication in order to make any transactions. Right, well, let me say that, Thailand, when we put forth this provision of law in our ETA, we did not think about it by ourselves, okay? We did not produce this provision of law by ourselves, but we, in fact, copied the ideas from, the international instruments. There have been, in fact, attempts by the United Nations. They attempt towards international instruments, okay, the intended to provide legal infrastructure for the use of data messages or electronic means of communication. Okay, the UN puts forth. In fact, the UN has its internal organ known as the UNCITRAL. Okay, the UNCITRAL stands for what? UNCITRAL stands for the United Nations Commission on International Trade Law. UNCITRAL is in charge of what? In charge of the making the international law in order to promote international trade. So it has been felt by the UNCITRAL that the use of data messages would cause sort of legal obstacles which would have to be removed. So the UNCITRAL puts forth 2 model law. One model law is known as the Model Law on Electronic Commerce 1996. The other one is the Model Law on Electronic Signatures 2001. Okay, so we in this country, in Thailand, we just copy this 2 model laws. We copy provisions of these 2 model laws. Okay, and put this, put the concepts or put, the key provisions of this model law into our ETA. So if you understand, the provisions of this model law, then you will also understand, the provisions of Thai law. You will also understand the provisions of our ETA, because our provisions are, in fact, the products of what? The product of replicating the concepts, okay, or, the provisions embodied in these 2 model laws. Right. In fact, in addition to these 2 model laws, the UN also, the United Nations also, step forward to toward enacting the convention, a convention known as the Convention on the Use of Electronic Communications in International Contracts 2005. As the name suggests, okay, this convention is in fact, okay, that is focused on what? Is focused on the conclusions of international contracts. It is focused on the conclusion of international contracts by the use of electronic communications. The word electronic communications in the conventions, okay, it is equivalent to the word data message as used in the model law. Okay. Now, the UN, through its Untitled, also made the most recent development by putting forth also the new model law, the model law on electronic transferable records 2017. This is something very new. In order to respond to what? In order to respond to the use of transferable records, for instance, checks, okay, negotiable instruments, which are in the form of data messages or electronic records. If you just draw e-checks in place of paper checks, how can you just transfer the checks? How can you just make endorsement? How can you just hand over the checks to the other party? Right? Because you do not have paper. The checks are not in the form of paper, but they are in an electronic form, so that Astro just work out the rules regarding regarding electronic transferable records. But back to Thai law, the ETA. The ETA again, our ETA, it is a product of what? The product of replications of the ideas from these two model laws, the Astro model laws on e-commerce 1996 and the Astro model law on e-signatures 2001. Okay, but when our act was in use for about 15 something years, okay, even though we now Thailand, we have not yet been any party to this convention on the use of electronic communications in international contracts 2005. We have felt that some provisions of this convention seem to be very useful. They seem to reflect some new, the legal developments, so that we should just put some the provisions in this convention into our ETA, so that our ETA has been amended by the Act number 3 in order to just import some provisions in this convention into our ETA. Okay, we are going to look at this, not today, but maybe next week when we talk about electronic contracting. Okay. Now, let me just say again that our ETA, it is the product of replication from the two model law, and also later also from some provisions, okay, of the convention on the use of electronic communications in international contracts, right? But the thing is that Thailand is not alone, okay, in just borrowing or taking ideas from the instruments prepared by the UN, by the United Nations, okay. But many countries also have done the same. We can see that in many countries they also have the ETA, or the Electronic Transactions Act, which seem to be modeled after the model laws on e-commerce, the model law on e-signatures, or also the UN conventions on the use of electronic communications in international contracts. Right. look at the position in, so let's say, in Singapore. In Singapore, they also have the ETA 2010. In fact, they first had the ETA of 1998, but they repealed the 1998 Act. Okay, and they put forth the Act of 2010. Okay, in place of the Act in 1998. So, because Singapore seemed to be very, very fast in terms of the law enactment. Okay, in Australia, they also had the ETA in 1999, as amended in 2011. Okay, in order to be responsive to some legal developments as reflected in the UN Convention on the use of e-communication in international contracts, as we have mentioned earlier. Okay, and in New Zealand, they also have the ETA in 2002, also amended in 2011. Okay, look at the year here. The ETA of 2002 in New Zealand. New Zealand had the ETA even after Thailand, okay, because in our country, in Thailand, we had the ETA of what? ETA of 2001. So back to the ETA of our country, the ETA of 2001. 1 year before, even 1 year before New Zealand. Okay, so we seem to be very fast. We seem to be fast in terms of what? In terms of having the law or enacting the law, but we seem to be very, very slow, I should say, in terms of understanding the law. And we have made too many mistakes also in the law making. I mean, in relation to the ETA. We are going to discuss this later as well. Okay, so don't take me wrong. Don't take me wrong that I try to blame I try to put too many blames on the ETA. Yes, the ETA have some good characters, but the ETAs, what I would like to say is that our ETA also contains a lot of mistakes or some misconceptions, okay, which need to be put right. But unfortunately, some fallacies, some mistakes, some shortcomings in ETA, okay, that remains in the Act. I would like to just bring you to this, to all these the policies later, okay, not now, right? Right now, just now we talk about what? We talk about the functional equivalent rule. Remember that I have just brought to your attention that this functional equivalent rule, it is the way to get rid of legal obstacles which have been produced by the use of data messages in place of paper. Okay, and this functional equivalent rule is embodied in Section 7 of the ETA, okay, which is in fact, okay, a replication of Article 5 of the Modern Law on E-commerce 1996. Because if you look at the Article 5 of the Modern Law on E-commerce, it says information shall not deny the legal effect, validity or enforceability solely on the grounds that it is in the form of a data message. See, so if you compare with our Section 7, you can see that the wording seems to be very, very similar, because we just copied from Article 5 of the Modern Law on E-commerce, the Untitled Modern Law on E-commerce. Right. Now, so nowadays we have the ETA, which, okay, allows us to make use of electronic means of communications in place of traditional means of communication. We can just switch from the use of paper or paper-based documentation to the use of data messages or electronic records. right? So we should not have any worry that transactions which are made by the use of electronic records or data messages will not be given legal effect. Transactions which are concluded or which are made, in the form of a data message should function or should be given legal effect in the same way as transactions which are made in the form of paper-based documentation. Okay, but I should just bring this to your attention. Okay, this is very important. Even though section 7, even though the functional equivalent rule as embodied in our section 7 of the ETA, says that from now on we can just make use of data messages in making transactions, without any worry that our transaction will not be given legal effect. But you have to bear in mind that the law also sets some minimum requirements in relation to some scenarios. It does not mean that you can just switch from paper into data messages in order to make transactions in any way you like. In some contexts, the law realizes that there may be some risk. The risks of, let's say, the risk of security, the risk of errors, whatever, or the risk of whatever. So that what the law does is to set some minimum requirements with respect to the use of a data message in making transactions. In these 4 scenarios, not in all scenarios, in these 4 scenarios, that if you want to make your transactions, in the form of a data message, make sure that you comply with the minimum requirements as required by law. These 4 requirements are first. These 4 scenarios are first, the scenario involving writing or written evidence. Secondly, the requirement as to a signature. Thirdly, the requirement as to original, and finally, the requirements regarding retention of information. If you want to retain your information in the form of a data message in place of paper documentation, then you can do so, provided that you comply with the requirements, minimum requirements set by the law. So we will explore all these minimum requirements, in relation to these 4 scenarios. But now, let's have a break for about 10 minutes. I would like to stop the lecture, the first part of my lecture here first. And I would like to stop the video clip here. And after the break, we are going to resume the class, and I'm going to just make new recording. Using another video clip for your convenience. Until then, thank you very much for your attention, and see you very soon in part 2 of this lecture today. Thank you. See you soon.